Karen, exactly what happened in the last few minutes as that case wrapped up for the day?
Well, essentially what we've heard is that the bank, Standard Bank in particular, are going to launch their argument. Standard Bank bringing an application that will essentially ask that the court order that no member of the executive can get involved in bank-client relationships. And we're expecting to hear more substantively from the banks about why they are supporting Finance Minister Pravin Gordhan's bid to get a court order that he should not be expected to intervene in the Gupta's relationship with the banks, who we know severed ties with them in the wake of the so-called Nenegate scandal.
Moot point, given that the Gupta family lawyers agree with Pravin Gordhan that he should not intervene.
Well, they agree, but they also don't agree. They're saying that essentially anyone should be able to ask a minister or a member of executive to intervene in circumstances where they feel they have been treated unfairly. They say the minister has a discretion to turn down those kind of requests, and that he should simply choose to do so. At one point in their court papers, they described Pravin Gordhan as weak-kneed and suggested it would start a very negative precedent if any minister who felt pressure would simply turn to the courts in those circumstances. Of course, much of those kind of mudslinging allegations they've now been forced to retract after that striking off application was successful by the minister. But a whole set of striking off applications, including ones bought by the Gupta companies, about the FIC certificate, about the Mcebisi Jonas affidavit, and about the Guptas themselves asserting that Pravin Gordhan and the banks were colluding. All of that subject matter being struck as evidence in this case. And really the heart of this matter now is whether it's appropriate or not for a member of the executive to intervene in a private family's commercial interests.
We've in fact just received a statement from the company Oak Bay that was in court today, the Gupta-owned company, saying they're delighted that the FIC report, Deputy Minister Jonas's affidavit, and any reference to either of them were struck from the Finance Minister's application. What does this actually mean? That the contents of 72 transactions that are deemed by some, including the Finance Minister, to be suspicious, as well as Mcebisi Jonas's affidavit, no longer form a part of this case?
Well, essentially what it means is that state capture is off the table in this particular piece of litigation. Remember, of course, that the Minister of Finance had relied quite heavily on the Public Protector's State of Capture report, in which she ultimately concluded that the President should launch an inquiry into allegations or evidence that it appeared that certain members of the Cabinet had inappropriate relationships with the Gupta family. He used that in his application and much of the paperwork to justify why he felt it was inappropriate for him to get involved in the Gupta's dispute with the banks. Now, what is so fascinating is that, of course, this application came after Mosebenzi Zwane, the Mineral Resources Minister, made that somewhat strange statement on behalf of Cabinet, stating that there should be a judicial inquiry into the banks. And subsequently, Cabinet denied that they were involved in the statement. He rescinded it, but there's a big rhetoric in the Gupta's court papers, Oak Bay and Sahara's court papers, that what Minister Pravin Gordhan is essentially trying to do is shield the banks from potential judicial inquiry. And we're going to hear much more of that kind of argument when this case resumes tomorrow, given the kind of questions that are currently hanging over the banks as well in terms of collusion, those recent Competition Commission findings about that issue. It's going to be fascinating to see how Oak Bay and Sahara frame their argument in terms of that particular issue.